Hello, everyone, and welcome to another episode of Women Winning Wednesdays. I'm your host, attorney Elsa W. Smith, the owner of the law offices of Elsa W. Smith, where our mission is to empower women through estate planning. Again, like I said, I hope that all of you are ready to take notes and get some good information today. Our topic today is estate planning when your spouse is ill. It's can be a pretty sensitive topic, and I was inspired to do a segment on this today based on a fairly recent consultation that I had. Um, Despite the easing of restrictions of, masking restrictions and stuff, and regardless how, what side of the fence you are on that issue, um, despite the fact that there is an easing of restrictions, people are still dying of COVID complications, and others are dealing with, life threatening illnesses, such as cancer, heart attacks, and strokes. When your spouse is the one who is ill, the pain is intensified, right? It's magnified because you're seeing the potential loss of a life partner. And it is truly, truly heartbreaking. So, my talk today is going to be broken into two parts. The first part is what you should do if your spouse has an estate plan. And then the second part is going to run down a list of 10 things you should consider if your spouse doesn't have an estate plan. So, having said that, let's go ahead and get started. Again, as a reminder, just let StreamYard allow StreamYard to view your comments when they're posted. Um, Here we go. The first thing, review your fiduciaries. So, what are fiduciaries? Again, those are the people who are playing important roles of trust in your estate plan. So, you want to see who's named in your spouse's estate planning documents to serve as personal representative. Some people may know the role as executor and trustee of your spouse's estate. Okay, they're going to have important roles when when your spouse passes away. So you need to be sure that you're comfortable with the people that have been selected fiduciaries, and it's okay if they change. People's statuses, conditions, relationships with, your spouse may have a different relationship with the person that was originally assigned as a fiduciary in a particular aspect of the plan. And, you may have had your spouse and that person may have had a falling out. So that's why I say it's always okay for these roles to change. Be sure that your spouse is still comfortable with the choices that he or she has made. And if your spouse has been sick before, chances are you've probably looked at the healthcare power of attorney or advance directive and a power of attorney. If you haven't, make sure and take a look at those documents as well. Next thing you want to do is review your assets. Determine the effect on your assets when your spouse passes away. Get an updated list of all of your assets, your spouse's assets, and see if there are assets that are held jointly and which ones within that list pass to you immediately upon your spouse's death, or if there are assets in your spouse's name alone with no transfer on death beneficiary provision. See if any of the assets have already been transferred to a trust, if your spouse created a trust. And the answers to those questions are going to determine how easily you can access certain assets when your spouse passes away. Along the same line, review your trust documents, your spouse's trust documents specifically. Any assets that are currently in a trust will or will pass into a trust at your spouse's death will be controlled by that trust document. So you want to see who the beneficiaries are, how distributions are made, and who will control the assets. Is your spouse still happy with the choices that he or she made, or do changes need to be made? The next issue, get ready for probate if it applies. And again, as a reminder, probate is a court supervised process. That one thing, it authenticates the will, if there's a will, and approves your spouse's personal representative, so he or she can distribute their property and belongings. Now, during the probate process, all of the assets must be located. All of your spouse's assets must be located and assessed for their total value. So once that done, taxes and debts are paid, and then the remaining value of the estate is distributed according to the will. Again, if there is one. If not, if there is no will, then the laws of the state of residence of the deceased will govern. If there is property solely in your spouse's name with no transfer on death beneficiary, those assets will pass according to his or her will, or the laws of the state in which they resided. Review the will if there is one to make sure that you both understand it and whether probate is going to be needed in order to settle your spouse's estate. The next thing, your spouse, you'll want to review the beneficiaries in your spouse's estate plan. Again, we're talking about if there is something in place already. Make sure that the beneficiaries on, say, retirement accounts and life insurance policies are current. Again, these things can change over time, and it's okay if they need to change, but you certainly want to just take a look at them again. Is a good idea, just as a best practice, to look at them on average every 2 to 3 years, or upon the happening of a major life event. Next thing you want to look at is home ownership status, and I talked about this a minute ago. In many cases, depending on how the deed is titled, if you and your spouse own your home jointly, upon one spouse's death, their share passes immediately to you, and you become the sole owner. Again, review the terms of your deed. Review retirement assets. When it comes to 401ks and other retirement benefits, these are non-probate assets that have beneficiaries, as opposed to an asset that's named in your will. And this means that you're going to fill out that your spouse would have filled out forms from his or her employer, or if it's a bank, a beneficiary designation with the banking institution, to list who he or she wants as beneficiaries. The next thing, be mindful of formalities, and this is going to vary from state to state, but there are certain formalities that must be followed. For example, for a will to be enforceable, it needs to be in writing, signed by the testator. In this case, it would have been your spouse, or someone signing at his or her instruction and in his or her presence. It also needs to be, at least in Maryland, it needs to be signed in the presence of two witnesses. Um, let's see. Right, that's correct. And it does not, and by the way, it does not, at least in Maryland, the will does not need to be notarized. Now I want to switch to part two, like things you should consider if your spouse has no estate plan. And let me say before I review this list, don't beat yourself up because you didn't get these things done. What I will say is that if your spouse has been diagnosed with a serious illness and he or she still has the ability to make decisions on their own, there is still time. Some diseases are more aggressive than others, more debilitating there than others, but as long as your spouse has the ability to make decisions on his or her own, there's still time, and you need to take advantage of that time because it's going to make things a whole lot easier if you can get things squared away. The first thing is to consider a durable power of attorney. Again, the power of attorney allows an individual to take actions on in this case, your spouse's behalf. Um, the other thing you want to consider is a living trust, usually called a revocable living trust. It becomes irrevocable when the individual passes away, when they die. Create an advanced healthcare directive. Um, really, estate planning is not only about what happens to your stuff, your assets when you die, but it's also about the quality of life you have while you're still here. Now, why an advance directive? Well, in Maryland, the advance directive has two parts. One is where your spouse would designate who he or she wants as the healthcare agent, the person who they want to speak to the doctors on their behalf. And then the second part is known as a living will. And it describes three distinct end of life or near end of life scenarios. And it asks for how your spouse wants to be treated, what kind of healthcare, medical treatment they want. And that's something that an estate planning attorney can walk you through and explain anything that needs to be explained. But that's something that really, honestly, everyone 18 or older needs to have an advance directive, and that can be placed on file with your spouse's medical provider, with their primary, if they have a primary physician. Also, apply for Medicaid if you qualify based on income. And as a reminder for those that don't know, Medicaid is a state and federal program that provides health coverage if you have very low income. All right. Consider a special needs trust to, if your spouse is disabled, his or her ability to stay on Medicaid, or if they qualify for, SSI, supplemental security income benefits, without going over the financial limit and those restrictions. Again, something else you want to explore with an estate planning attorney. Create a list also of the assets that you own. This is, by the way, one of the tips that I give in my free resource. It's called the Jumpstart Estate Planning Guide. And you can get this free resource by going to my website, elsawsmithlaw.com. Go to the resources tab, and there's a drop down, and you'll see the Estate Planning Jumpstart Guide. Get that, and you'll see in 7 steps, it's a way of just, again, jumpstarting the process. Better late than never. Get on it, do it again as soon as possible. The other thing you want to do is locate pertinent or relevant financial information, including prior tax filings. If you've got the last 5-6 years worth of tax documents, those are good to have handy, because particularly if the estate may go through probate. That's something that in creating generating the final tax returns that may be important to have prior tax returns available. The other thing to consider is to purchase long-term care insurance if you haven't done so already. Now, huge asterisk. I want to mention that according to there was a 2019 AARP article that noted that the national median daily cost for a private bed in a nursing home was $280 per day, or over 102,000 per year, and a year-long stay in your own room at an assisted living facility runs just over $48,000 per year. So this is one of the long-term care insurance question is one of those things that you want to consult with your, trusted financial planner, who has knowledge specific to long-term care policies. And keep in mind that, unfortunately, the longer you wait, the more expensive and perhaps even cost prohibitive it may be to purchase long-term care insurance. I've seen articles lately of just how long-term care insurance rates have really just skyrocketed. So whether you can qualify, or if you are fortunate enough to be able to self-fund, just again have that discussion with your financial planner, and make the required decisions. But at least you need to keep that in mind, because those expenses really can get out of control and can really eat into other assets that you or other beneficiaries may need to live on. So it's a really important question to address. Two more things. One, purchase adequate medical insurance if you haven't already done so. Your spouse should have appropriate medical insurance. And again, this is probably something you already have, but I just wanted to mention it. And then lastly, your spouse needs to decide who his or her primary caregivers are, who he or she wants as their primary caregivers, if this hasn't been discussed already. As I always say, the time to do things is not when you're in chaos, is not, waiting until the disease, the illness has progressed to such a point that your spouse cannot articulate what their desires are. That's too late. That's a problem. If they are not competent to make decisions, even they don't have to write it, but if they can't even articulate it, they're not competent enough to make their own decisions, that's a problem. Then you have to consider other means, which are probably going to be more expensive for you to pursue. The time to do things is not when you're in chaos. It is now. I keep beating that drum in the hopes that people, that it clicks for individuals. But I also want to say that, like many of us who have procrastinated, we're human. But it's not too late to make things right, to protect yourselves and do the right thing, and provide the dignity and a good quality of life that your spouse deserves. So take what I've said, make notes, contact an estate planning attorney in your state. We provide that sort of assistance for couples, regardless of the age, in the state of Maryland and in the District of Columbia. That's what we do. We're a wills and estate planning firm. We are here. We want to be that trusted partner with you through all of the stages in your life, but particularly in the final stages of life of your spouse, which is the topic of our segment today. I want to thank you for your attention and for just being part of the Women Winning Wednesdays community. This was a difficult issue, I know, for many of you. And, you know, if you catch this on the replay, share it. Tell me what you think. Reach out to us if you're having, if you're going through this right now. We're here to help. Don't hide. Don't, do the ostrich thing and just stick your head in the sand, because it's only going to make things worse. We're here to help. Thank you again for tuning in to another episode of Women Winning Wednesdays. I am attorney Elsa W. Smith, your Maryland estate planning attorney, saying, I don't know why I'm at a loss for words all of a sudden, but I just want to thank you for tuning in, and I will see you in our next episode. Have a good and safe week, everyone. Take care.